Well, good afternoon, everybody. My name's Monty Mills. So those of you who are here this morning may have heard I'm a new professor here at the University of Montana in Indian law. I also work in the Marjorie Hunter Brown Indian Law Clinic. I came here from southern Colorado, where I worked for the Southern Ute Indian tribe for a number of years. So I've been given the pleasure and honor of moderating a panel on climate change and energy, two very discrete, simple, straightforward topics for which I'm sure we can figure out how to achieve success in the near term. So in thinking about my role as moderator, I tried to think how this panel might fit with some of the other panels, also how the panel might fit sort of with the overall theme. And I think there are some distinguishing characteristics about this panel that maybe help put it in context, but then there's also some similarities, I think particularly with the secret sauce concept, which has sort of guided us since Solicitor Tompkins mentioned it. So first of all, some distinctions, it seems to me. Perhaps unlike some of the other topics we talked about, climate change as an issue really seems like the ultimate transboundary issue, right? You have water basins, you have wildlife habitat, but really climate change affects all boundaries and may cross every single boundary across the globe. Secondly, it seems a little different with regard to the timing. Would there have been a panel on climate change, say, 10 years ago, maybe 25 years ago? Even if this panel were held 2 months ago, it would have preceded the issuance by the federal government of the EPA's Clean Power Plan, which is specifically aimed at climate change goals and also has big effects on energy production going forward. It would have preceded standards issued by EPA on ozone and carbon pollution. And it also would have preceded one of perhaps the most visible developments on climate change, which was President Obama's visit to Alaska late this summer, the stated purpose of which was to highlight the impacts of climate change, particularly on Alaska Native communities. So perhaps unlike the River Tweed Act of 1807 or the Winters case of 1905, the discussion of climate change is sort of newer to the game. Similarly, I think with regard to some of the other more discrete topics, wildlife and water, we've heard already the impacts that climate change could have on those more discrete topics. And here we're talking about both climate change and energy, where it seems the impacts of energy are more directly on climate change rather than vice versa. And lastly, what do we mean if we are to achieve success in the climate change context? How do we know if we have slowed, stopped, reversed climate change? I'm not a scientist either, like others, and some running for president, but certainly it seems much harder to determine whether or not we've achieved success with regard to climate change. And with regard to energy, it seems the definition of success is much harder to reach too. For some, the definition of success with regard to energy production would be to minimize certain sources, maximize other sources, perhaps prohibit some sources, while others who may rely on those very sources would define success exactly opposite. So it seems there are some unique aspects of this particular topic that may not be translatable across the other panels we've heard today. However, what about in the context of the themes we've talked about, the secret sauce? There are many catalysts here, right? Energy production is a catalyst for climate change. Climate change is a catalyst for these new policies that the federal government is rolling out. Jobs as a catalyst, and economic development as a catalyst for energy development. And how about Indian tribes as perhaps a more recent, a more modern catalyst in both energy development, in terms of economic development, but also new concerns about the potential for energy development as it relates to places of cultural importance or sacred sites. There are issues of leadership here. I mentioned President Obama's visit to Alaska and highlighting climate change and energy, really, as issues with regard to that particular visit. Also highlighting Native issues in a visit to Alaska. That aspect of leadership is clearly present here, which is a theme we've talked about. Science came up as a theme in terms of trying to achieve success. Clearly, science is going to play a major role in how we assess, determine, potentially achieve success with regard to climate change. So, our excellent panel will illustrate various aspects of these complicated topics, both climate change and energy. And while perhaps unlike some of the other examples we've heard, we may not be able to demonstrate truly achieve success, particularly with regard to solving the climate change puzzle, there may be some interesting, I know there will be some interesting themes that come from the specific examples we talk about. And I'm looking forward to moderating and involving you in a discussion at the end of our panel about how maybe those themes can be applied more broadly in this context. So with that, let me introduce the true stars of the panel. I think we're going to start with Tim Presso. He is a managing attorney for the Northern Rockies section of Earth Justice. He, I just learned, coming from the West, did his time back east in D.C. and now has returned back to the right side of the Mississippi River for some of us. And he does, as demonstrated in the biography materials in your book, works on a number of important issues in his role at Earth Justice. Second up, we'll have Del Lavager. He is an enrolled citizen of the Crow Nation. He also serves as special advisor and counselor to Crow Nation Crow Nation Chairman Darren Old Coyote. He was a consultant also at Aiken Gump, Strauss and Hauer and Feld. And I came to know Del in his time with Department of Interior, as some of our other panelists have been. He spent 3.5 years there in various roles, all in Indian affairs. And lastly, Mark Safdie. He's a Worth Chair in Sustainable Development with the School of Public Affairs at CU Denver and a partner at Holland and Hart for 25 years, where he's done a number of interesting and fascinating things described in more detail in your materials. With that, I'll turn it over to Tim, who's going to lead us off.
Thank you. I think I'm kind of the fly in the ointment of your conference about cooperative solutions, not only because I'm an unapologetic litigator, and not because I don't think cooperative solutions are valuable. I think they're terrific when they can be achieved, and I think we've heard some amazing success stories today, but I also think that litigation can be tremendously successful and transformative and can play an extremely useful role in our society. You may have heard of something called Brown versus Board of Education, for example, which I think we'd all be a lot worse off today if there hadn't been a litigation campaign on that issue, and of course many others. But I don't think that the conference organizers are going to allow me to use my entire time to talk about that theme. So what I am going to talk to you about, and the reason I think I'm sort of the fly in the ointment, is because my talk is about a situation in which it appears at least that all the cooperative solutions have been squeezed out of a particular resource issue. And what remains are the last pieces for which cooperative solutions seem to be elusive. And that is the issue of threatened energy development in the Badger II Medicine region of northern Montana. We can orient ourselves here a little bit to, if you're not familiar with the landscape we're talking about. This is the Rocky Mountain front of Montana. The landscape running from the Canadian border to McDonald Pass, one of the last great wild places remaining in the lower 48 states. If you look at a map of sort of the road footprint in the lower 48 states, what you'll find are there are very few large white spaces left on the map, and this is one of them. It's a reminder of what we've lost elsewhere, and it's also a reminder of what we can achieve in other places if we responsibly and intelligently manage our natural resources. And the Badger II Medicine is a critical part of that. I know there are two screens, but you can just look over here for a minute. The Badger II Medicine is this little block right there, just south of Glacier National Park, north of the Bob Marshall Wilderness Complex, a roadless landscape of about 130,000 acres on the Lewis and Clark National Forest that, to today remains unprotected by law and is a very vulnerable landscape. Why Badger 2 Medicine? Why is that name? A lot of people wonder what does that name come from? It's because the drainages of the 2 Medicine River and Badger Creek flow through the area, although I recently learned Badger Creek is actually a misnomer, that the initial word name that the native people had for that area referred to a bear, not a badger, but because the bear is such a potent entity in their world and they didn't want to reference it for fear of disrespecting it, they told the white people it was Badger Creek. And it's just an example of sort of the discordance between our cultures that colors this entire issue. So what's so special about the Rocky Mountain Front? Why should we care about it so much? The Rocky Mountain Front is this incredibly diverse landscape where the Great Plains meet the Rocky Mountains. And so we have incredible plant diversity as you move from plain species through foothills to alpine. You have incredible wildlife habitat. It's been identified as in the top 1% of wildlife habitat in the lower 48 states, retains virtually the full suite of wildlife species that were here pre-European settlement, with the exception of bison, and there are plans afoot to reintroduce bison at appropriate places on this landscape. It's got the second largest migratory elk herd in the United States, and it's the last place where grizzlies roam out from the Rocky Mountains onto the Great Plains. So there's a lot that's special here to preserve. And indeed, there has been a history of preservation in this landscape, ranging from the designation of the Sun River Game Preserve in 1913 all the way to Congress's enactment of the Rocky Mountain Front Heritage Act in 2014. But the history of preservation and conservation in this region is not unbroken. Anybody know who this guy is? That's right. James Watt, Secretary of the Interior under President Reagan from 1981 to 1983. His articulated viewpoint was that America was divided into liberals and Americans. And he was the first president and CEO of the Mountain States Legal Foundation, which is an organization dedicated to the advancement of property rights and development rights. And when he came into office as Secretary of the Interior, he announced an agenda to mine more, drill more, cut more timber. He suggested opening 80 million acres of undeveloped federal land to drilling and mining. He did indeed quintuple coal mining under his watch in 2 years. And he leased 1 billion acres of offshore waters to oil and gas companies. And he leased the Rocky Mountain Front. Under an ambitious, aggressive leasing campaign that rolled out in the early years of James Watt's stewardship, oil and gas leases were issued up and down the Rocky Mountain Front. That was in the early 1980s. This is now 2015, of course. There's a lot of history since those days. And over the course of that history, many of those leases have been wiped off the landscape. Some were enjoined or canceled by federal courts. That's the non-cooperative solution. Some were voluntarily relinquished or bought out after transformative kind of catalyst events, including, for example, when the Bureau of Land Management announced that it was not going to move forward with an environmental impact statement to study an oil and gas development proposal not too far out of Choteau, Montana. And many of the leaseholders decided to sell out their interests. Congress then passed a mineral withdrawal of the Rocky Mountain Front that provided tax incentives for many leaseholders to relinquish their interests. And over the course of that time, about 110,000 acres of leases were removed voluntarily through cooperative agreements. That was tremendous, a terrific result. But some people did not accept the hand of compromise. And today we deal with the legacy of the Watt leasing here in 2015, the last remnants of that aggressive leasing campaign. In some respects, in one of the most sensitive parts of the entire region, the Badger 2 Medicine, the last 40,000 acres of leases, which you can see indicated in red on the map. The green nearby are those that were voluntarily relinquished. The majority of those 40,000 acres, 22,000, are held by an Oklahoma energy company called Devon Energy, which has been very quiet throughout this controversy. But leading the charge for the leaseholders is a holder of a single lease, a gentleman named Sidney Longwell, who owns a company closely held company called Solonex, that owns a 6,000 acre lease and is now the focus of attention. The Solonex lease encompasses this place. The drainage of the South Fork of the Two Medicine River, Hall Creek area, 6,000 acres directly south of Highway 2. If you've driven around the south end of Glacier National Park, between West Glacier and East Glacier Park, you've driven along the very northern boundary of the Solonex lease, but the lease extends well into the backcountry south of the highway. And those 6,000 acres are in their own right a pretty important place. This is the evidence of one of the Badger Two Medicine inhabitants that some Montana Wilderness Association hikers found on one of their forays into the area. It's great grizzly bear habitat. In fact, this area of Highway 2 along the edges of the Solonex lease is one of the best connective habitats for grizzlies moving from Glacier National Park further south into the National Forest lands and then on into the Bob Marshall Wilderness. A recent study by the Wildlife Conservation Society showed that there are multiple places along this corridor where grizzlies can still cross the road. Highway 2 and that whole corridor with a railroad and a highway is a pretty major connective issue for bears or any other kind of wildlife trying to make that crossing. But because north of the highway you've got a national park with an extremely protected landscape, and south of the highway you've got roadless area, basically a de facto wilderness. Bears still cross here, including female bears with cubs, and it's a special reason, a special place for that reason. It's also excellent habitat for elk and mountain goats. The entire Badger Two Medicine presents great habitat for wolverines, west slope cutthroat trout, lots of species that we have here in this part of the world that don't exist elsewhere anymore. But the wildlife aren't all. It's also a very special place because of its cultural importance to the Blackfeet people. This is really the sacred heartland of Blackfeet territory. It's the site, it's central to their oral history of themselves as a people, their traditions, their creation stories. It's the place where their ceremonies, the most sacred ceremonies are conducted. It's the place where during the boarding school era and the era of repression of Native American cultures, that Blackfeet people could get away from the Indian agents and the BIA officials and go and still maintain their traditions. The peaks all bear the names of key figures in Blackfeet oral traditions. And today, it's still a place where plant gathering of medicines, sacred rituals occur for the Blackfeet people. It is not a historical cultural resource. It is a living cultural resource of a living culture that survived the Holocaust of the bison, survived the boarding schools and the repression and the allotment of Indian lands. And it still persists, and there are still traditionalists who carry that forward, and this is the heart of their cultural identity. And for that reason, it has attained recognition for those resources as well. In 2014, the keeper of the National Register declared 166,000 acres of the Lewis and Clark National Forest, including the Badger Two Medicine and specifically the Hall Creek area, as a traditional cultural district of the Blackfeet people under the National Historic Preservation Act, meaning an area that is important to maintaining the cultural identity of a community. It's the highest recognition in federal law for the cultural resources of a people. But the legacy of the leasing remains, like a time bomb lurking on that landscape, ready to disrupt all those things that so many of us care about on that landscape. The history of the lease development issue, like the lease itself, goes back many years. In January 1993, after a flurry of permits and appeals, finally a high-level official in the Interior Department, the Assistant Secretary of Interior, approved a drilling permit for the Hall Creek lease. It means 6 miles of road construction into the area, a new bridge over the Two Medicine River, a 4-acre well pad, an exploratory well, and of course the nose under the tent of development for the remaining 40,000 acres of leases in the event of a successful well. In response, in April 1993, the National Wildlife Federation and other organizations filed a legal challenge in the District of Montana, And this was right after the period when the George H.W. Bush administration gave way to the Clinton administration. Secretary Babbitt was looking for a solution to this issue, and the solution he arrived at was to issue a suspension of operations and production on the Hall Creek lease. Now, a suspension is a concept under the Mineral Leasing Act 30 U.S.C. 209 that says that no development can occur on the lease, but at the same time the lease does not expire. An oil and gas lease has a standard term of 10 years, although in practice the rules are set up pretty much by the industry acting through the Interior Department such that a lease will never expire unless the industry wants it to expire. But in this case, through a suspension, the running of the lease term itself was stayed. That may sound like ancient history, but in fact it's the last chapter. Because the suspension remained in place to this day. Issued in 1993, here we are 2015, the suspension's still there, and Sidney Longwell got tired of waiting. And on that score, you know, honestly, I can't really blame him. I think most of us would be annoyed if we had a contract with the government and the passage of 30 years prevented us from ever obtaining any benefit of that contract. So Solonex, in June of 2013, filed suit in a federal district court in Washington, D.C., alleging unreasonable delay in the lifting of the suspension on his lease. His lawyers, anybody want to guess who his lawyers were? Mountain States Legal Foundation. James Watt's legacy emerges once again. In July of 2015, a federal judge ruled in the case, criticizing the 29-year suspension and saying, in colorful language, no combination of excuses could possibly justify such ineptitude or recalcitrance for such an epic period of time. Clearly the judge deemed this to be inappropriate, and I wasn't terribly surprised to see that result. It is an extraordinary delay, of course, but is it legally offensive delay? You know, one of the things that we in the environmental community found after a case called Southern Utah Wilderness Alliance versus Norton, which some of you may be familiar with, was that these cases to force government agencies to act got a lot harder because the Supreme Court said you have to have a mandatory duty to take action underlying your case before you can force the government to take a delayed action. And in this case, suspensions by law are to be granted, quote, whenever the secretary in his judgment deems it is necessary. That didn't sound like a mandatory duty to us. And so we raised in defense of the Longwell lawsuit the point that, hey, if when we sue the federal agencies, we have to identify a mandatory duty, then Mr. Longwell should have to do the same. And what he's really talking about here is a discretionary duty, not a mandatory one. The judge did not address that question and just simply moved to the epic delay to justify the ruling he issued. So things were going Mr. Longwell's way. But a key question that's not even involved in the Solonex lawsuit looms over the entire controversy. And that is, are the leases themselves even legal? And this takes us back to the Watt-era leasing campaign once again. Anybody know what this cruddy-looking place is? No? North Fork of the Flathead River, area along the western border of Glacier National Park that runs into British Columbia, spectacular, low-elevation, unroaded valley, and also ground zero for one of the Watt leasing efforts. It was, however, challenged. Those leases were challenged in a case called Connor versus Burford. Those of you studying public lands law may have encountered Connor versus Burford because it is one of those cases that comes up time and time again in the interpretation of NEPA and the Endangered Species Act. And the issue in Connor versus Burford was what level of environmental analysis needs to accompany the issuance of an oil and gas lease. The government said, hey, it's just a piece of paper. We sign the piece of paper, we hand it to the energy company takes the piece of paper. There's no environmental impact from that. What the court observed in rejecting that argument was that issuance of leases actually is a major federal action, significantly affecting the quality of the human environment, requiring an environmental impact statement. Why is that so? Because once the lease is out the door, even though no shovel has hit the dirt, the right to develop has been conveyed. At that point, the government can regulate where the development will occur, when it will occur, what kind of equipment can be used, but we can no longer regulate the question whether development can occur. That decision has been made once the lease goes out the door. And that's why they said, you've got to study that before the lease is issued. Guess what? James Watt's leasing campaign did not include any environmental impact statement before the leases were issued. Similarly, under the Endangered Species Act, the approach the government had taken was, hey, it's just a piece of paper. We'll just do a short form analysis that says issuing a piece of paper doesn't do anything to endangered species. Down the road, when the well drilling rig gets ready to move, we'll study the impacts. And the Ninth Circuit said, no, you need to do a comprehensive biological opinion before the lease and project what are likely post-leasing developments and figure out what are those going to do to endangered species so that we don't end up in this train wreck scenario down the road where somebody has a lease right and the survival of an endangered species is on the line. Another James Watt era leasing controversy gave rise to another set of legal holdings. Anybody have any idea where this place is? Another part of the Rocky Mountain front called Deep Creek, very near the town of Choteau, Montana, another spectacular landscape that James Watt thought looked good for an oil field. Case called Bob Marshall Alliance v. Hodel concerned the fate of those Deep Creek leases. And the Ninth Circuit in Bob Marshall reiterated the Connor holdings. You got to do an EIS, you got to do a biological opinion before you issue the leases. But it took things a step further. Said under NEPA, and I know this is really getting into like the public lands textbook for you guys, but I figured since it's a law conference, we could take a deep dive here. Under NEPA, you got to consider alternatives to the action. And one of those alternatives has to be not doing the action. That way you can say, okay, here's what the environmental effects will be if we do nothing, and here's what the environmental effects will be if we do our proposed action. And that comparison can reveal to you what's at stake in this decision. Problem is, in the Watt-era leasing campaign, they didn't study the no-action alternative. They said, well, it's against James Watt's policies not to lease, so we're not even going to study that option because it's really not on the table for us. And the Ninth Circuit said, no, that's not how NEPA works. You need to study the impact of all possible approaches, including total abandonment of the project. That turned out to be quite critical because when the case came back down to Judge Hatfield, who used to be the federal district judge out in Great Falls, he issued a landmark ruling. And while Connor v. Burford had issued an injunction that said we're going to prohibit surface development of these leases, but we'll leave the leases in place, Bob Marshall Alliance said, because you didn't consider the no-action alternative, a different remedy is required. Cancellation of the leases is, in this court's opinion, the only remedy which will effectively foster NEPA's mandate, requiring informed and meaningful consideration of alternatives to leasing the Deep Creek area, including the no-leasing option. So the decision that Judge Hatfield made was you've got to wipe the slate clean by canceling the leases and putting everybody back to the drawing board at square one and not let the vested lease right color any of the analysis to follow. So where does that leave the Badger II medicine leases, this last remnant of James Watt's handiwork? Well, there was no pre-leasing environmental impact statement. Just as that, this was all done from the same playbook by the Interior Department, and they followed the same process for all these leases. They were leased in a very close time frame with each other. They didn't do an environmental impact statement. They did not consider the no-action alternative. They just said, well, we'll lease immediately, or maybe the other option would be we're going to revise the forest plan. We'll wait and lease after we do the revision. So instead of no action versus action, it was lease now versus lease later. And there was no pre-leasing consideration of reasonably foreseeable post-leasing activities. So the case for the invalidity of these leases is pretty strong. But what can be done about it? Well, the government has the authority on its own right to cancel a lease that was unlawfully issued. So in October 2014, the Blackfeet tribe and conservation groups separately requested lease cancellation actions by the federal government, said these leases should be canceled, there's too much at stake here, and there's no cooperative solution available. These are the people who turned down all the cooperative solutions. They're the last ones left. And this is a cancellation request that has picked up momentum in the ensuing months. In March 2015, Senator Tester chimed in with his own support. And under a process that is triggered by the National Historic Preservation Act, the government's highest authority on cultural resources, this was in the news recently, you may have seen some of these headlines, through the Section 106 process of the National Historic Preservation Act, issued its own advisory recommendation that the Interior Department revoke the suspended permit to drill, cancel the lease, and ensure that future mineral development does not occur. So there's a lease cancellation campaign underway. If you drive through the Blackfeet Reservation these days, you might see a billboard that looks like this. So where do we go from here? Well, the government has laid out a schedule that says at the end of this month, the U.S. Forest Service is going to recommend to the Interior Department whether to cancel the lease. On November 30th, the BLM, U.S. Bureau of Land Management, is going to determine whether to accept that recommendation. If it does, the lease will be canceled by March 30th, 2016. If it does not, there will be a lengthy process to address the environmental impacts of development that is scheduled to conclude by July 2017. But all of this is occurring with the final word from the Federal District Court in Washington, D.C. not yet registered. And the judge is holding a hearing on October 6th to take the measure of the government's proposed schedule. And I strongly suspect he's not going to be too excited about 2 more years of epic delay, as he called it. So I wouldn't be surprised if you see headlines on Wednesday in the newspaper saying that this judge berated and browbeat the government's lawyer about the extended delay that they propose. So we'll see where this is headed. The story has yet to be finalized, and you all will see in the news how this all shakes out and what ultimate solution is possible, and whether these lands can be protected, or whether we talked about how the Badger II Medicine is a sacred area, but for some elements of our society, the lease contract is itself a sacred pact. And whether which of those two competing interests is indeed more sacred in our system at this time. But I don't want to close this discussion without hearing from some of the native voices on this issue, because it's one thing for me to stand up here, a white lawyer, and talk about the Badger II Medicine, but really the people who have such a close cultural identity with it should be heard from. So I just want to play for you just a 2-minute film that the Blackfeet people have put together about this issue that I want to leave you with.
You can't really put it into words, but you just feel it, the beauty, and you feel connected when you're there.
We call this our homeland. We don't have anything else. That's our way of life. We were pushed to this area. Our people have every right to question things today.
I imagine what my grandparents did in those mountains. And just the water that comes out of Badger Creek, it's just so pristine.
I don't believe for a second that the people of Montana don't appreciate the Badger II Medicine area.
Our basic needs are water, food, and the solace of the area. Them are basic needs that are there, that are provided no matter what. And if we allow oil and gas development in the Badger II Medicine, the real foundation of who we are will be gone.
Dear President Barack Obama, my name is Earl Oldperson, Chief of the Blackfeet Nation of Montana. The Badger II Medicine for thousands of years has helped shape the identity of the Blackfeet people. We're going to fight for this area that we call our home.
We need to light a fire under ourselves. We need to become more passionate. We need to become more vocal. We need to become more forthright. It's a perfect place, needing a perfect solution.
Thanks a lot.
Good afternoon, everyone. I'd like to thank Professor Ball and Williams and the conference organizers for an opportunity to speak here today. By way of background, normally for the Ipsaloke people, the English version is Crow, but we call ourselves Ipsaloke, children of the large-beaked bird. So, Biabsaloke, Nawabishichish, Balasayichish, Bahogajila, Balakbaga, Bapobasesh, Bagondilish, Hina Digyuku. I just introduced myself in the Ipsaloke language. One of my spiritual names is First Stone. It's actually a mountain range that is still protected and part of tribal ownership. And the second one is Walks Above, which was given to me when I was appointed by President Obama to the Department of Interior for Indian Affairs. And I think that's important context because what I'm about to share with you is the conundrum from probably the last 2 days of the conference on the balance between sustainable, environmentally responsible energy development, the real concerns of climate change that we have many people have seen, and I know that Native peoples all over have experienced, and I know that firsthand because as I served the President's first term, I got to visit many, many homelands. There's 567 federally recognized tribes. There was a focus on one here, the Blackfeet Nation, who we have a lot of respect for, and then the Crow Nation here. But I'm going to give you a broad overview of kind of the layers of public laws that impact tribal nations, and then take that down a level to where the unique legal history between the Crow Nation and the United States, and then show you the difference, actually show you the decimation that happened, and then all of the burdens and responsibilities that still remain on those very important public policy decisions on whether to develop or not. And I think it's very difficult for people to understand unless you at least have a broad sketch of what has happened. Some of it was referenced in the prior speaker's discussion, and I'm going to give you some specific examples here. And then I'll probably switch back and forth between the federal and the tribal level because I think it's important in this discussion. I remember being at Interior back in '09 after President Obama came in. The Crow Nation adopted President Obama back in the campaign of May of 2008, gave him a Ipsaloke name, which is he who helps throughout the land. And so we have a special relationship with him, and we're very proud of that. So we do consider him our relative, and I'll show you a picture at the end to show you that the relationship continues. With that, let me go ahead. You see the Kevin Red Star painting here of the stars, just to give perspective. You know, that we have 3 mothers, your birth mother, the teepee, and the sweat, which are protective mothers, recreating in the sweat to purify yourself. And then, of course, Mother Earth. And so, at least in the Ipsaloke tradition, it's always that no one is without a mother. You will always have a mother as you walk your path through this life on Mother Earth. So just to get the really high level, it's not even 30,000 foot, I would say it's more like 100,000 foot. And I'm not going to go through all of these, but you can see basically that federal policy changes about every other generation. The rules change. The foundation changes, and depending on who's in office, unlike maybe some other areas that are more specific, you could have a shift. And as noted in the last presentation, just on the shift on who's the Secretary of Interior and who's not. Well, here, many of you likely know that there was just an assertion of federal title to Indian land, and that's an important thing to say at the outset, that Indian land is not public land. Just as a general statement, if there's no takeaway other than that, that's a really important distinction because you start to run into problems not only like the Blackfeet have and others who want to do renewable energy, and they always got to run into federal numerous steps in order to create development and jobs. And so it really cuts both ways because of the numerous federal laws, regulations, and policies. And believe me, working through that bureaucracy on any number of fronts is very difficult and time-consuming. And the bureaucracy is born of this, right here, starting with so-called settlement discovery, treaties of equality, 371 federal tribal treaties, and I'll get into a couple examples with Crow. I know that the Blackfeet have a treaty with the United States as well. Many of you have heard Trail of Tears. It actually began in New York first in 1817, where there was removal of many of the natives there over to the Midwest. And so you'll see a lot of relationships between Wisconsin, Michigan, some of the other states down in the lower Midwest, and tribes that were originally in New York and still have connections there. Allotment and assimilation, I'll show you a specific example of what that means. And then termination era in the late 50s, Congress said, we're going to terminate that relationship between tribal nations and the federal government, liquidate their assets, give them a payout, and then call it good, and they don't have a connection to their homeland. Many of those policies are still reflected as some of the tribes are trying to rebuild themselves and come to Interior for help and say, help me navigate this so we can reestablish our homeland. There's some pretty heart-wrenching stories out there, particularly in California, where you had 109 tribal nations that were terminated and are now still seeking restoration. And then finally, tribal self-determination, the origins of which belong in the Nixon administration to end the termination era. And then this is really the rebirth and rebuilding of tribal nations, as the Harvard Project on Economic Development likes to say, the rebuilding. They were already there, they faced all of this, and now they want to reconstruct themselves to be where they were once before, as independent people with connections to others on the outside. And you see what happened. You talk public lands. Public lands largely came from the cession of tribal lands. And so there's a historical connection between the two. Even Glacier National Park is referred to in the Blackfeet language as the backbone of the world. And you'll see in a number of traditions, at least in the plains, and I'm sure in the Southwest. I went down into the Grand Canyon. I heard the Colorado River basin discussion. I remember going down in there where the Havasupai live, the original people there. They're the mother of all the other ones, including the Hopis and a variety of others. And I remember being down there and just, you can sense just the connection for a community that's been there so long and sustained themselves down there. It's a really phenomenal place if you ever get a visit. I'm sure some of you have seen on Discovery Channel or likewise. And the fact that they have irrigation and they take care of themselves with a lot of challenges, to be sure, but it's a pretty phenomenal place. So you see just the massive land loss, after the Civil War especially. The then political leaders said, turn your attention to the West. A lot of things we want to go do. Gold was discovered in the Black Hills and precipitated the Lakota-U.S. wars, which the Lakota initially won those battles but lost the war, and likewise. And then you can see when you get down to, roughly 25 years after the post-Civil War, you can see the land slowly dwindling for tribal nations, and then you see 1990, not much change from there. So what does that mean? You can give maps, you can talk about policies, and then I think you really got to drill down because each tribal nation has its own history. And what I guess the takeaway I would have for anyone who works at Interior, works for NGOs, works for any number of folks that have an impact on tribal nations is you have to drill down and get to know that tribal nation's specific history to understand where they're coming from, their perspective, their orientation. I mean, they're the original inhabitants of the area. They want it protected too. They want to seek allies and friendships, partnerships. They want to cross boundaries, and they finally want to have some tiny piece of the American dream. Clean water, a home, the things that so many people just take for granted. And believe me, I saw down in stretches of the Navajo Nation where there's 30% of the community has electricity. So you get way out there in their homelands, and there's just major, major challenges, third world country conditions, really. And so that's the challenge. How do we lift them up when they only have a certain resource that folks don't like the impacts of, and it's a very small contributing factor, a fraction of a percent of whatever it is domestically, but still it's a challenge from a public policy perspective. And I'll get into the Crow story here very quickly. So zeroing down to Montana, we've left the 100,000 foot level, now we're at the 30,000 foot level. You can see what's left largely of the purple boundaries, and then the Crow Nation down there, Psalika people down at the bottom. So even though I told the federal policies, now here's just a quick summary of the Psalika and the United States policy, the relationship between us. Actually, in 1825, the Apsáalooke Nation had a friendship treaty with the U.S. The U.S. said, can we cross your land? If we can cross your land, we promise to forever be friends, and if you've got enemies, we'll help you out. You help us out, we'll help you. This is still federal law, right? I mean, even today, even 190 years later, sometimes you've got to remind folks in Washington, D.C. that your ancestors met our ancestors and you promised. So it's time for you to uphold that promise. Fast forward to when the United States was creating territories, etc. And so there's an 1851 Treaty of Fort Laramie. And in that treaty, there were 19 tribal nations that signed. In Fort Laramie down in southern Wyoming, going towards some folks here from Colorado. But if you take that drive, there's a historical site there. And one that which is still very significant to the Apsáalooke people. I was told by our current chairman, Old Coyote, a number of years ago that oftentimes they'll bring the Apsáalooke youth down there. And they'll go down there and they say that the kids can feel it because there was a sacred ceremony there, a bond between the United States, all these tribal nations, and the Crow Nation, and that bond was meant to be forever. It wasn't supposed to be temporary. You get this land, we stay in this part of the land, you uphold your part. And so often they'll take the youth down there just as a reminder, and they can feel it. And it stays with them for the rest of their life, which is really important connection. Well, the 1851 treaty, I have 3 separate presentations. I'm a recovering professor myself, so I'll try not to go too far with this. Back in Wisconsin and Michigan State University, seems like a lifetime ago. The 1851 treaty had a provision for 50 years. So the Crow chiefs, what the treaty commissioner said, 50 years of payments, schoolhouse, you know, all the stuff you hear about in treaties, some basics, some food, and of course, you know, Buffalo Bill was doing his part, you heard of it alluded to, so they're promising rations from the military and at the same time, you know, annihilating the ultimate spiritual and food source of the very people they're dealing with. You know, that's the term forked tongue historically that you hear. In the 1851 treaty, though, there was 50-year provision. It goes to Washington, D.C., and the U.S. Senate unilaterally changes it to 15. And it was never addressed, so look what happens 17 years later. They unilaterally changed 50 to 15, so then they're running out of food, the buffalo are being decimated, and they're saying, okay, let's go for another land cession, because we know you're out of food. So then 1868, and I'm going to show you a map of these land cessions. It's no mystery, the timing of all these things. And we still have a variety of places around the Crow Nation that we refer to where there were meetings before, all these times that are here. And oftentimes we're taught about those so that it's never forgotten. Just like Crazy Woman Mountains, how many of you have been around there near Bozeman? There's a Crow story connected to that. And I can't tell all these stories in one presentation, but Yellowstone Park, obviously being Crow Nation connected to that. We've got words for almost everywhere in that park. And I'll show you the map to show you how connected we are to that. So after the treaty, 1871, Congress says, we're done. House of Representatives sick of being told by the Senate, you got to fund this because the power of the purse comes through Ways and Means. Otherwise, you can't get anything through Congress. And so they stop treaty making, and then they go to so-called agreements. And by that time, you know, the forces had changed, where the U.S. had gained power, tribes were starting to get diminished, the food sources are going, the land's being ceded, and so then there's just a consistent set of agreements. And so you can go through this history with whether it's Blackfeet, whether it's the Wind River down in Wyoming, whether it's the Navajo Nation, etc., parallel stories. And of course, the railroad going through, 1864, the United States had said, transcontinental railroad goes through, all rights of way needed for the railroads to go through because we need it for manifest destiny. Well, that wasn't mentioned in the 1868 Fort Laramie Treaty. You already granted authority over Crow land, and then you came back and asked for the land that you already granted. I mean, just once you dig down deep in this, you just see the injustices, and you know, you have to contain your emotions and really get back to the thought creating those, and then get into the history, the factual background, in order to really appreciate just the number of things that were happening in a very condensed period of human history. And it has been decimating. So you have the railroad acts. Those were like, I think one of them was $5,000 for the right-of-way, once and for all time. You get these other agreements, which are land agreements, and then after all that land around it has been ceded, then the feds come back and say, and we want to carve up the inside too. And I'll show you the impacts of that. And then these are later cases where the U.S. opened it up and said, if you've got claims, tribal nations against the U.S., bring your claims, but there's all these stipulations on it. And guess what the stipulations were? You can only claim what the value of the taking was at the time it was taken. So you have to do 1868 land values, even though we didn't compensate you for that. And you cannot include interest. Can you imagine if interest is included on all these claims? I mean, we're talking breaking the bank. And ironically, out of all this, I had a colleague back in Wisconsin who, from South Africa, post-apartheid. And he came to me and said, I'd like to meet with you and talk to you, Del, because I hear you're very knowledgeable about tribal nations and the treatment of the U.S. And I said, well, why would you want to know this information? He said, I want to know what not to do down in South Africa. I want the land to return. You guys had a bunch of claims that weren't the value of what actually it was, and you didn't get the land back. And that's what we don't want to do. Isn't that an interesting statement for him to say that to me? And it parallels in other parts of the world as well. In U.S. versus Montana, this is a heartbreaking case for us, where the United States, I mean, the U.S. Supreme Court essentially made up legal rationale to say, okay, Crow, you've always been here. You've been here first. You don't want folks killing ducks because they're part of our creation story, so you regulate for them not to. Later on, they've had a fee patent in the reservation by the river, and the Crow tribe took the position that we don't want you killing the thing that's part of our creation story. Goes up to the Supreme Court, and they said, normally there's the equal footing doctrine. I don't know how many public lands people, equal footing doctrine on how states are created. They're supposed to be equal, and equal to 13 colonies, etc. Well, the equal footing doctrine that's applied to tribal nations would be the tribes were here first, right? So they should have underlying title to land. Well, the U.S. said under exigent circumstances in non-navigable waters, the title passed to the state. So the state somehow, even though they were created in 1889, and after the 1864 Organic Act, the tribe already had these treaties to secure this land. How could Montana own the riverbed if Crow was always there and they were there first? How does that happen? How does Montana own title to that? You have to make up a rationale in order to get to that result. Anyway, it's led to all sorts of jurisdictional problems. You can imagine on the fishing, who collects the revenue from that, and ultimately Crow never got one penny. And then the Campbell farming case, it was a case about allotment, and they said, Crow tribe, you don't have standing. Some individuals need to bring this case. And then finally we reorganized in a 2001 Crow Constitution, which looks kind of parallel to the U.S. Constitution with some caveats. So here's the map of the land cessions. If you look at it, you can see the out dotted line is the 1851 boundary, which parenthetically includes all of the Powder River Basin in northern Wyoming, or north central Wyoming. And then you get down to the darker one with the colors is the 1868. That's 8 million acres. It started at 38 million. And then you see the land cessions for what is now Bozeman, Absaroka, et cetera, and then north of the current Crow. And so you can see each of these impacts just diminish down to the boundaries of where we're at today. And so here, even with all these federal policies, how did it apply to Crow specifically? Well, we had a self-sufficient ag and ranching efforts in the early 1900s. It was productive. Even with that, it was still usable. Had the largest horse herd in the world and a cattle herd of 30,000 head. And then you can see a variety of other things, and I'm going to speed it up a little bit. So as a result, there's about 2.2 million acres. The tribe owns 500,000. Individual Crows own 1 million. And then there's 700,000 owned by non-Indians. And then today, there's folks who still are impoverished and they're selling their land for money, don't have much other for resources to live day to day. And then if you look, and I'll show you a map here, those latter stats are fractionation. So after it was allotted, and then folks, Indians start dying without wills, and it goes out, and then one generation, the next generation, you end up with an average of 42 owners per tract, and sometimes up to 200. And that's what led to the Cobell. I don't know how many of you have heard of one of the largest class actions against the United States. We're 10% of Cobell. That's what it looks like. So there's what federal policy has done to Crow. The light pink is tribal, the dark pink is individual Crow, and then the rest is the non-Indians. That's what you have to deal with when you're making a decision on, do we develop? Where do we create housing? Where do we put a wind farm? What do we do with this? Obviously, lots of challenges. And so you get a large number of owners, reduce the value of land, effective management's not possible. How do you collect lease rentals? How do you get all the signatures when you have people all over the place? How do you track them down? Where are the records? And then, all of these, if you develop, it costs twice as much, takes twice as long. Same with renewables. It doesn't matter whether it's renewable or non-renewable. And then recently, good efforts by the President and Secretary to get the Cobell settlement and return some of those fractionated lands back. So here's the coal resource on the very eastern side. You can see on the very north part is the Upsalica mine, which has been about a 5 to 6 million ton per year, largely sent to near Minneapolis to power the Midwest. And then you have the Southern Spring Creek on the southeast corner, and that's what the coal resource is, and almost largely undeveloped. Well, if you decide to develop, then you've got to go through the org chart, which you've probably already heard from Solicitor Tompkins, so I can skip over that slide on what it's like to be the top lawyer for all these different agencies. But just note, the Assistant Secretary of Indian Affairs is down there in those 5 blue boxes, and that's the world that was the world that I inhabited for the President's first term. And then so you get that little blue box, then here's one set of boxes that you've got in the organization. It's $2.5 billion in Indian affairs, 10,000 employees, 12 regions, 96 field offices, and that's what tribes have to navigate on whatever they're doing. Whether there's trying to do positive development, or whether it's trying to stop development, whether it's trying to get an individual lease, whether it's whatever it is, housing, commercial, etc. And there's another box that goes down to the local levels and offices. So back to Crow. So they make a decision. They've had one lease for leasing coal, and it was up north, and then a recent lease down on the south end. And the important part here is you could see the Bighorn River. That was the Montana case I referenced in the middle. And so the elected Crow leaders have said, okay, let's study wind development. They tried. The best class 5-6 winds are right near sacred sites. So there was a policy decision to not develop. We're trying to do a hydropower project. It was going to be 9 megawatts, and we're running into access to transmission issues. We'd love to do a hydropower project. We'd love to do a lot, and if solar worked, we'd love to do that as well. So we have the present mines, and the important part is that second line, 2/3 of Crow revenue is from that small mine on the north. 2/3 of Crow revenue. So when the Clean Power Plan hits, you can see that you're going to see a precipitous nosedive in Crow revenue, which is about $20 million a year for 14,000 citizens. Not very much, and that's how our government runs. And so the idea has been to find another project to at least get some out there, and then you run it. We had the Harvard report done, and it shows the positive economic development impact if it were to happen. We know it's an extremely challenging environment, and again, this isn't my decision. This is the Crow people who elect their leaders, and they decide whether they want to try to develop or not. We wanted to do coal to liquids, and we struck a deal in 2008 with an Australian partner. It was going to be a mega project. We wanted to get clean burning diesel fuel for the U.S. Air Force, and the 2009 recession hit, and the deal just fell apart. All the credit lines just went down. And the important part in the advancement of technology with this is now instead of just CCS, I don't know how many of you have heard of carbon capture or sequestration, and I know a lot of folks don't want to hear the sequestration part. The part that's forgotten that we're focusing on is the utilization of the CO2. Take the CO2 off, put it in an algae plant, bring it back as biofertilizer, and increase farm yield. That's what we'd like to do with it, so that we do something positive with the CO2 and it's just not emitted. Unfortunately, the administration hasn't been totally behind coal to liquids, and so it makes it difficult if you don't have someone there to help partner with you in the early risk period, and also support the technology developers that can do the utilization of the CO2. That's really the most important part, and China's doing it in the Gobi Desert right now. They're growing greens out in the middle there, no one thought was possible, and experimenting because they know they've got serious, serious CO2 problems that are impacting the world. And in the lead up to Paris, and you saw India saying they were going to reduce as well. So I'll just finish up here. I mean, our relationship still continues with the Obama administration, the chairman and I in the Oval Office, renewing that commitment together, to work together, to try something. We call him our relative, we bless the office, we know it's been hard times for him, and we thank him for his leadership. And he's got a little piece on his desk on the back there where he sits down at the desk when he signs various bills. And I don't know how many people know this, but in there it says, "Hard work is hard." That's what he has as a reminder when he sits down every time. And the Chairman Old Coyote and I were just laughing, and we said he's been through a lot. There's no doubt, and he needs all the help he can get. And so we're trying to be, reasonable, be responsible environmentally. 50% unemployment. Potentially with the Clean Power Plan, that would go up to who knows what the percentage is. If the mine were gone, we'd be at 90-some% unemployment. We'd be in serious trouble. And all the Apsolica people tell us is, we want to be responsible. It's our homeland. We'll make sure it's taken care of. We've always been here. It's in our teachings. We will make sure that it's done right. But we got to have jobs. We need education. And you got to take care of the elders. And if we don't have anything, how are we going to do this? I don't have any answers. We're trying everything we can. And so I'll just close with this, that it is a difficult balancing act. And sometimes when you have forces that want it going in a direction, and it's a good way. I served in the administration in climate change and standing up centers, and the biggest thing we tried was to get tribes included. How are you going to get tribes to deal with climate change? Help them do adaptive management. Help them to manage the streams that are there, that are connected to all these other partners and governments and NGOs. Let them have a seat at the table. But in the end, if that community decides that they need that to survive, as the Crow leadership has told me, then we have to proceed with caution, but at the same time we have to proceed with the only resource we have to monetize in order to survive as a people. Balakbaga. Say Ahoak Baradia. They said the Creator endowed us with this. Use it wisely. Just be careful and make sure to take care of the people. And make sure to take care of all of Mother Earth and the creation that's there. That's all we're taught, and that's what the Crow leadership is trying to do. So thank you for your time and attention. I appreciate it.
With your permission, I'm going to do it from here for a couple of reasons. One, I don't have any PowerPoint presentations or film clips. I personally believe that things like PowerPoint and film clips are for the intellectually weak. I think you have to be able to sit here on your own and talk and make sense. This presentation I'm about to make is very short. I don't need pictures to convey to you the message that I'm going to convey, so I'm going to do something I rarely do, which is go without. How many of you have read or seen or followed any stories or writings or books written by Thomas Friedman, the New York Times op-ed journalist? Tom Friedman told me at a dinner one evening about 10 years ago that a revolution would have to occur globally and would occur in this country. A revolution that grows out of concern about climate change, a revolution that grows out of concern about the way we make and consume electric energy and other forms of energy for transport, And this was on the heels of the publication of one of his more recent books, a book called Flat, Hot, and Crowded. Friedman said over dinner that evening that he was in the dentist's office or a doctor's office a few days earlier and had been reading the magazines on the table in the doctor's office, and there were stories about how to have a green wedding, what's the most green hair dryer you can buy, how to green up your home. And he said that's not a revolution, that's a party. In a revolution, people get hurt. The existing order gets completely inverted, turned over, reassessed. I'm going to close out this panel discussion today with something that's a little different from what you've heard before, but hopefully ties together or stimulates some thought about what you've heard and seen today in compelling photographic and visual form. How that fits together with the revolution, or how it doesn't fit together, or how we need to think about the revolution. Because make no mistake about it, we've come in a decade to a point where the revolution is upon us. If we think there's been transformative change in the last generation, in the way we live and the way we do things, we're right. Think Kodak. Think landlines. Okay? 3 out of the 5 last hotels I've stayed in around the world did not have landlines. They had a phone that could connect you to the front desk. When I started practicing law, there was no such thing as a mobile home. Well, there was, but you needed a suitcase to carry it around in. Right? The energy transformation has been happening. It's been building. It's been talked about. But the next generation is going to look like a powerful revolution. Del, I don't know how we're going to address the economic needs of the Crow as this revolution approaches and is on us. But I have some ideas. I think the revolution has enormous potential benefit for the public lands, like the lands that Tom talked about. And I'll offer you a 30-second thought at the end of my remarks here to leave you thinking about it. In some ways, I feel like I'm being punished. I left Montana 25 years ago, moved to Denver, where I've pursued my career in the law by developing renewable energy projects around the globe, really, 38 states, every continent. We've developed wind and solar and other kinds of renewable technologies. But being put at the end of this panel discussion today makes me feel like somebody had it out for me. These were compelling presentations, gentlemen, and I'm pleased to be here. The reason the invite to come here and talk was timely for me was because about 3 weeks ago or a month ago, the Rocky Mountain Land Use Institute asked me to author a portion of a book that's forthcoming. It'll be out next spring. A book that's being released in celebration of the 25th anniversary of the Rocky Mountain Land Use Institute. I was asked to prepare the portion of the book that relates to the nexus between energy and land use. So when I was invited to come to this conference and make a few remarks, I thought, well, good, that's cool. I can piggyback on the work I've done, thinking and observing and reflecting and doing research for this book. So I'm not all the way along by any means in completing that portion of the book, but there are a couple things that I have already discovered are true and are going to stay with me. And the one thing is the themes, the two themes or forces impacting the nexus between energy and land use that control and dictate everything that's happened in the last quarter century and everything that will happen in the next quarter century have to do with two, as I said, themes. The first theme is growing, increasing awareness and concern and action around climate change. I'm not here to talk about whether it's real or not. It is. Secondly, the profound technological transformation that's going on out there and the effect that profound technological transformation is having on not just the way we think about and use energy and will use energy, but the cost of energy. The technological transformation that's driving costs to where they are. So 25 years ago, if we worked in the business of land use and energy, we were focused on how do you get a lease to drill in a wilderness area? How do you get or develop a lease to extract coal on the Crow? How do you design the land use systems and methodologies we have to use to get access, to build whatever it is we're going to build, extract whatever we're going to extract, convert whatever we extract into a usable form of energy, whether it's gasoline or electricity, and transport or transmit that stuff from wherever we get it and make it to where it's used. The world indeed is flattening. Those traditional structures of how we get and consume and convert fuels and energy into usable power for ourselves is being inverted. I spent my entire career working in the traditional model. You go to a very big bank with a very big company, and you borrow an enormous amount of money, and you build a very big project, and that project produces a fuel or electricity or some energy-related product that is distributed, transported, and sold and used to the public. The world is changing. It's becoming local. Everybody is lending to everybody else to develop things that are flatter, more distributed, more local, and it's unstoppable. It's inevitable. In the past 20 years, in the past 10 years, the cost of solar panels has declined 140 times. 8 years ago, I worked on the very first utility-scale solar electric project ever built in the state of Colorado. Small project, 7 megawatts of capacity, against a system in Colorado of about 7,000 megawatts. 7 years ago, the company that developed that project in the San Luis Basin sold the electricity generated from that project to the utility in Colorado for $225 a megawatt hour. 7 megawatts, $225 a megawatt hour. Does that mean in relation to the price of electricity from coal or natural gas? Easily 8 to 10 times higher, 7 years ago. 3 weeks ago, a client that my colleagues who still do work, because I don't much anymore, completed the financing, development, and placing into service of a 300 megawatt solar project. 300 megawatts. And the price the utility in California is paying for the electricity from this project, $50. Okay. In 7 years, that's a fourfold decrease in the price. And we observe also that a good-sized solar project has gone from 7 megawatts to 300 megawatts. Okay. What does all this mean for the way we think about land use and land and the myriad other issues that are associated with this revolution? Okay. It means that we still have a lot of complex issues to address. It means that as lawyers and policymakers, we still have to think very hard about things like externalities. Okay? We've complained forever that we don't value and give proper consideration to the negative externalities associated with the development and use of carbon and fossil fuels. We have health issues. We have health issues in New Mexico and Colorado and southern Colorado associated with the long-term combustion of coal to make electricity adjacent to the tribal lands down there. The health issues impacting the tribal members in southern Colorado and northern New Mexico are well documented. Emphysema rates are off the charts. We've never valued those externalities. We have to do better at that. We've valued positive externalities. I'm tired of the word subsidies. I'm really over it. There's this ongoing, long-standing debate about whether we subsidize renewable energy at the same rate we subsidize oil and gas. Well, oil and gas subsidies originally were not a giveaway. They were subsidies. They were a valuation of positive externalities. The positive externalities in the 20th century associated with oil and gas development were an improved economy, more electrification, better health systems, better roads. We gave tax breaks to the oil and gas industry and to the coal industry, like the depletion allowance, because they had a positive externality effect. Our policymakers said, let's incentivize and reward that. We're doing the same thing now, or have been for a decade, with the renewable sector. We're saying there are positive externalities associated with renewable energy. Let's subsidize. Those days are about over. I think we need to eliminate any payment for positive externalities and make the playing field level, and most people are arguing for that because technology, in particular solar and wind technology, have driven us to a point of parity. It will be, I promise you. You won't have heard it here first. Anyone who has read a book about energy and the future has heard these arguments, but I promise you, energy will be cheaper by a half or by a third from renewable sources a decade or 15 years from now than it is today. There is an inescapable trend. There are technology improvements occurring now and on the horizon that are unstoppable. Elon Musk, Tesla Motors, right? His gigafactory in Nevada. I remember being just a little bit shocked when I heard that Elon Musk was going to spend $5 billion to build a battery factory in Nevada. You know, how many electric cars can you sell that will justify the cost of a $5 billion factory? About a year and a half went by. The factory was completed, and a few months ago it started producing a few products, a series of products, one of the leading products of which is a battery that hangs on the wall in your garage and looks a little bit like a central vacuum cleaner, about that size. And it can give you storage for the solar panels on your roof. And by the way, when sun's not shining, it can draw power from the existing grid to keep the battery at least half full to 2/3 full. In the first 2 weeks, when the Gigafactory turned its sales force loose globally to sell these batteries, orders with reputable purchasers backed by substantial financial security for $800 million worth of this one kind of battery were placed within 2 weeks. This is not a gamble. There is a real, profound, active market out there. The solar industry has grown in the United States at an annual compound rate of 82% for the last 5 years. I don't see this disappearing. I see transformational change happening here. I see transformational change happening that we will look back on and compare to some of the transformational change that our generation has gone through. As people who think about land use, as people who think about public lands and native lands, we have to be cognizant of and familiar with this transformational change. And let me just ask you a couple of questions to close out my remarks that I really kind of made up on the fly here today based on these really wonderful presentations that we've had. Number one, does it make any sense to think about the transformation that will occur and our evolution away from fossil fuels, coal, oil, gas? Does it make any sense to think about making it a priority, a policy priority, that as the demand for those products, for those fuels declines, as it inevitably will, to make sure that the decline rides on the back of, first, the elimination of these drilling and extraction activities on all public lands? Does that make sense? That the first mines, the first oil wells, and all of the hydraulic fracturing sites that are located on public land should be the first to go as demand declines? Is it possible to have that as a policy? Is it a good idea? Is it a good idea, secondly, to think about the horrible, extended, dismal history of the United States governments and the state governments dealing with tribal nations, to say the last out the door, if coal is to continue to be extracted anywhere in this country for another 20 years, that the last out should be the mines on the tribal reservations. That the last out should be those sites where the economic benefit of continuing to do that as we need to would come from the native nations. 2 questions. No answers. Food for thought. Monty, thank you very much for the opportunity to be here, and thanks to all of you for your patient attention. Thank you.
Thank you all. I think we have time for questions. Yeah.
Why was the Badger 2 Medicine left off of or why wasn't it part of the Rocky Mountain Front Heritage Protection Act initiative? Was it just the existence of these 2 leases, or was it, what's the history there?
Yeah, in terms of a wilderness designation for the area, you mean? Yeah. Well, there are oil and gas leases that have to be resolved. The other thing is, the Blackfeet Nation has, I don't want to speak for the Blackfeet at all, but my understanding is that they have a concern with the wilderness designation that dates back to the 1895 treaty between the Blackfeet people and the United States that, many Blackfeet believe they have a different interpretation of that agreement, which conveyed the lands of Glacier Park and the Badger 2 Medicine to the United States. And they view a wilderness designation as a further assertion of federal authority over those lands. And, there may be opportunity there for some kind of a common ground to be found once the oil and gas threat is eliminated, if that happens. But I think that's been a factor in the past treatment of the area. Since, if it's okay, I do want to offer one thought about the climate change issue, because I was asked to talk about a very localized issue, but I do have one thing I wanted to contribute. Would that be all right, very briefly?
Absolutely.
Those are great presentations, very thought-provoking, both of them, and I've got a lot to think about from both of them. One thing I want to make sure, though, that is part of this conversation is, in terms of climate change, I assume you may know this, but if you don't, I want to make sure that it's said during this conference. There's some math that is, ultimately sets some absolutes here. The accepted wisdom is that we cannot afford to heat this planet more than 2 degrees Celsius. We've already heated above pre-industrial conditions. We're already at 0.8 degrees Celsius. So we got 1.2 degrees Celsius to play with. All of the international agreements on this issue operate at the 2 degrees Celsius is sort of like the ceiling, after which the habitability of the planet and the continuation of our civilization become very questionable. In order to not blow through that ceiling, we can burn an amount of existing carbon reserves. It's a big number, 565 gigatons. It's about 16 years worth of carbon burning at our current rate. Unfortunately, the proven oil and gas and coal reserves around the globe are at 5 times the amount that we can burn without blowing through the 2 degree centigrade ceiling. So the situation presented today, extremely compelling. I don't know the right answer to it. I thought the thought-provoking question at the end of the last presentation was really powerful and interesting. But I do think that we have to come up with a way to deal with the fact that 80% of the asset value of some of the major corporations that are driving our economy and some of the major oil-producing countries around the world is locked up in assets that cannot be burned if we're going to continue to inhabit this planet with our currently existing civilization. That's sobering. Unfortunately, we don't have leadership. Even President Obama, whose leadership on this has been unprecedented, he's not talking about it in those terms. But you don't have to look very far into this issue to understand those realities. They're real. And we have to grapple with that. And I just wanted to throw that out there because I think it sets some important sideboards for how we think about these issues and maybe provide some context for some of the other discussion we've had.
Another question for Mr. Bresso about if and how the Blackfeet's tribal constitution would be rewritten, and depending on how that plays out, will that have an impact or could have an impact on this issue with energy development?
Yeah, I mean, I wish some Blackfeet people were here today. I feel like a very imperfect spokesman for the Blackfeet people, and I don't even pretend to speak for them at all. I can just tell you what I know very briefly in answer to that. the Blackfeet people are interested, the current tribal leadership is interested in addressing its constitution, which is one of these, unfortunately, the blueprint for constitutions for tribal governments that came out of that history of statutory developments has been problematic for many tribes, and I believe the Blackfeet have been one of them. They certainly are interested in that kind of constitutional reform. The current leadership has talked about that, is my understanding. One of the things they have talked about importing into their constitution is that the Badger Two Medicine region must remain undeveloped, must remain this cultural heartbeat for the Blackfeet Nation, and so I think that does hold some promise. But again, Blackfeet can speak for themselves, and I'm not trying to speak for them.
Do you mind if I?
Yeah, please do.
And I wouldn't dare, as a Crow, speak for Blackfeet, so I'll just put that out there. A lot of horse stealing over the years. But, looking back at the threads, I mean, if you were to take a look at it, if you were to boil it down, there's really three kind of buckets of that history, if you examine it more closely. Consensual relations, implied subordination, and then outright paternalism. The outright paternalism is when those constitutions were pushed. And oftentimes they were for mineral extraction so that they could get a particular leadership, somebody to speak for the entire community. And so they wanted a politically elected, which is antithetical to how the order was. The order was, for example, for the Crows, we say, Bajechish, Iakodish, Diga, Iga. They're a good person, and they've shown that in the community. That's who led a particular group. And if you noticed in any of the battles, if anyone's seen it, and I'll be very brief here, when the person they followed into the battle fell, the Bajechish, everyone scattered. And if you go look back at Army military records, they always said, we didn't understand that if that one went, they would leave. Because they followed the person with the heart, compassion, connection, self-awareness, self-compassion. You had to have all those elements. And these new constitutions just have you go out and elect, like other places, and you run into these compounded problems of, rhetoric versus experience. And that distorts the vision. So, I'm not going to speak too far into the Blackfeet. I did speak at one of their Confederacy gatherings a decade ago, but that was why Crow changed, we wanted some traditional elements to it, but it makes it difficult when you're patterning and there's expectations from externally in order to get to things that are wanted internally. And I think that's the conundrum, and there's a big wave of change in Indian country on redoing that, reconnecting with the tradition in the ways that were done, reconstituting that government, and having somebody more reflective of that blend that's happened. There's no going back and changing everything back. You can't wave a magic wand, but you can protect what's left and blend it into what you have to make better decisions.
If there aren't any further questions, let's give another round of applause to our